2001, all disputes about land are subject to judicial procedures. The Land Code of 1991, full compensation and damage caused to citizen or property is entitled to full compensation under Article 276(1) of the Civil Code. That's in our evidence. We set out the compensation claims pursuant to the convention that you can get in Armenia. In Nagorno-Karabakh, they can sue, as other Azeris have done successfully, to have their land re-registered in their name. In other words, in Nagorno-Karabakh, people in exactly the position of these applicants have had their homes restored. From the Nagorno-Karabakh Defence Force in possession, the court has ordered them to be re-registered in their names. So, we can find in the Nagorno-Karabakh evidence they have a constitutional right to property under Article 9 of the Constitution, and they have remedies in Nagorno-Karabakh under the Civil Code. And the judges and the lawyers assert that they are ready, willing and able to do that. Our evidence in witness statements discharges our burden of showing that there are accessible courts, willing lawyers and remedies with a reasonable prospect of success if they can establish the factual basis of their claim. And that evidence includes evidence from the Office of the Human Rights Defenders. She confirms that she would assist the claimants if they asked. They complain that she hasn't taken action of her own volition. Well, of course, she needs to be asked by the applicants. There's evidence from the Public Defender's Office in Armenia that they've acted for Azeris. Evidence from the President of the Armenia Chamber of Advocates says, of course, lawyers in Armenia take cases from any persons without fear if the case is against the state. In fact, one Armenian lawyer, very experienced lawyer, whose name is Anahit Sargason, is actually very excited at the prospect of taking this very case. And she explains that we uphold the general ethical duty followed by both civil and common lawyers alike, that lawyers must not refuse to act on the basis of the nationality of their client or because the government is the respondent. So there awaiting in Armenia are the courts, the judges and the lawyers ready to process this claim. And so why has we've shown, we've proved that the courts are there, accessible remedies. What is the reason why they haven't flown to Yerevan, an important European city served by many European airlines, where the Deputy Foreign Minister affirms that they have never denied entry to Azerbaijani citizens as a policy. Any Azeri can obtain a visa for €5 at the airport and can go and hire local lawyers to begin their case. Well, it's rather confusing because they talk about a general policy. There's no general policy to deny Azerbaijani citizens entry to Yerevan. That's nonsense, never been suggested. So they can come to Yerevan, the capital of Armenia, and take legal advice and begin their action in the Armenian courts. That's proved. And the Armenian courts have jurisdiction over the army and can order compensation for any wrongdoing wherever in the world it's been perpetrated. So, and they have independent judges and they have the convention. So how is it that they haven't taken action? They say that, it's telling that no Azeri has ever succeeded in an Armenian court to recover property. Is it telling? What does it tell? Maybe it tells that, in fact, the Armenian army wasn't involved. The fact situation was that it was the Nagorno-Karabakh Defence Force, and that's why no Azeri has brought action. Perhaps the Azeris who have a good case, or any who have a good case, have been deterred by the mistakes and misunderstandings that these applicants and their lawyers have laboured under, that they can't somehow bring an action in Armenia. So it may be telling that they have no good claims to bring, or it may be telling that they've been given mistaken advice by lawyers who admit that they don't have expertise in the legal systems of Armenia or Nagorno-Karabakh. So that is no excuse for failing to exhaust domestic remedies if you have one. No excuse that your lawyers don't understand the local law. No excuse that you're poor. It's no excuse that you don't know or don't fully understand what your rights are. If any applicant could evade Article 35 by pleading poverty or the incapacity of its legal advisers, then the article would become a dead letter, and the court itself would have to take on the burden of sifting the evidence, which should be done, of course, through local domestic courts. It is, as I say, had these London-based lawyers who say, in excusing the fact that they haven't taken any action, that they're ignorant of Armenian and Nagorno-Karabakh law, had they bothered to come to Yerevan, they would have found the bar and the bench as independent and as unafraid to take on the government as in the UK. That concession, incidentally, that they didn't know Armenian or Nagorno-Karabakh law is found in paragraphs 151 and 152 of their October 6th statement last year. Turning to the remedies available in Nagorno-Karabakh, the applicants are free to sue there, and the evidence that we've put on from law defenders in Stepanakert might persuade them that they had a case they could bring, and they can bring. They're free to sue. They can obtain not only compensation, this is important for their remedy, in Nagorno-Karabakh, the court can restore their land. It will order the local authority to re-register the land in their favour. There's an independent court system in Nagorno-Karabakh, all our evidence shows. It applies the European Convention. The President of the Supreme Court and the local judge in Lachin, who's made a statement, say that the applicants are free to commence their action, that their remedies would include an order for repossession of their land. So the Lachin judge said in terms that he would order a discovery of government documents and allow them to cross-examine any government witness. He's at Appendix 9 of our 2012 submissions. The chairman of the NK Chamber of Advocates says he's acted in the past for his areas and he would act for them in land claims. And what is so important, particularly having heard from the applicant's lawyers that we can't point to one case of an Azeri succeeding. Not true. We point to two cases which are almost identical to the claims. These cases, Zafarov, he was an Azeri who lived in a house built by his father in 1961 in Nagorno-Karabakh. He fled as the war heated up, and in 1991 he asked NK authorities whether he could return. They assured him that he could, that there was no ban on visiting NK. In 2005 he returned, identified his house and asked the authority to give it back. The authority refused. He took the case to court. After careful examination of his claim, the court granted him an order declaring him the owner of the land and the House and ordering the government authority to register it in his name. So he had exactly the remedy that these claimants claim that they can't get. He went back, no problem. So too did Mr. Alayev. He fled in 1990, stayed in Russia. In 2002, he says he made inquiries, discovered there was no prohibition on him visiting. He sought registration, and the court ordered the Nagorno-Karabakh army to re-register the land they were occupying in his name. So these two cases, and we give the details of them, show conclusively that Azeris, in exactly the same position as the applicants, have domestic remedies in Nagorno-Karabakh, which are accessible, effective, and provide a reasonable prospect of success because they did succeed. Mr. Zafarov and Mr. Alayev. Read their cases, and there's a complete refutation of the claims that they couldn't come back to Nagorno-Karabakh and that they don't have domestic remedies there. They say, oh, the Armenian authorities will refuse us the right to return. We put on a statement, Appendix 13, from the Minister of Nagorno-Karabakh explaining that that was a bargaining chip in the Minsk negotiations, had nothing to do with the rights of individual Azeris to come back to Nagorno-Karabakh and claim their land. Two cases we've given, exactly almost the same as these applicants, where they have got their land back from the Nagorno-Karabakh courts. So the Zafarov and Alayev cases prove that domestic remedies are theirs for the asking. They've just never asked. They've never inquired of lawyers who have any knowledge of what's going on in Nagorno-Karabakh. Of course, 11,000 tourists leave to go to Stepanakert each year. It's a wonderful place with 1,000-year-old churches and so forth. It's ridiculous to suggest that there's any difficulty in getting there. Baroness Cox, who runs a charity there, makes a statement to that effect. So, but the applicants say at paragraph 151, and I quote, "Moreover, for the avoidance of doubt, the lawyers working on the case are qualified in the UK and do not have expertise in the legal system of Armenia or NK," unquote. This can't be a ground for exemption from the requirement to exhaust domestic remedies. Otherwise, anyone who chooses to complain against any state would say, oh, I'm absolved from compliance with Article 35 because I'm poor and my lawyers are underfunded and don't know anything about the domestic law remedies they're meant to exhaust. If that plea were ever upheld by the court, Article 35 would simply be a dead letter. So let us conclude on this first point by saying that our evidence shows the courts of Armenia and Nagorno-Karabakh are independent and impartial. They do afford these remedies. Lawyers are willing and able to take action against the government, have done so with success. And it's conceded that the applicants have made no attempt whatsoever to go for their remedies in those countries. Turning to the court's second question on extraterritorial jurisdiction, Armenia's adamant case is that no military units are in Nagorno-Karabakh or the occupied territories, that its conscripts, there are conscripts under the 1994 Status of Forces Agreement, which we have exhibited. There are several hundred conscripts in Nagorno-Karabakh who's serving in the Armenian forces, and there are about 1,000 we have in the identified from a Nagorno-Karabakh general about 1,000 Armenian conscripts who are serving under the control of the Nagorno-Karabakh